Okay, so here we go. So this morning we're going to be talking about, is your marketing breaking the law? The truth about GDPR and PECR. My name is Keith Budden from Insurity. We're one of the leading GDPR agencies in the UK, and we have just won the Theo Prophetus SBS award. So we are very, very pleased with that. Um, so this is one of a series of workshops that we're running. We run it every alternate Wednesday throughout the year. This is number 10 of our workshops. So if you want recordings of any of the previous ones, please do just let us know. But as I say, today we're going to talk about, is your marketing breaking the law? The truth about GDPR and PECR. So what are we going to cover? We're going to cover GDPR versus PECR. What's the difference? Because they are different. Common mistakes that people make in email marketing regarding these two. When do you need explicit consent? Practical steps for compliance. The consequences if you don't comply. Then we have the key takeaways, and then we'll have a few minutes for any questions and answers at the end. So, GDPR versus PECR, what's the difference? GDPR, which hopefully everyone knows, is the General Data Protection Regulation, which came into force on the 25th of May 2018. And it covers data protection and privacy rights. And although we're no longer part of the EU, we now have UK GDPR, which to all intensive purposes is the same as GDPR was when we were in the EU. Although the government is currently working on its data reform and use bill, which is working its way through Parliament, it's not expected to make any fundamental changes to GDPR, or UK implementation of GDPR, I should say. But then PECR is the Privacy and Electronic Communications Regulations, which covers direct marketing rules, which is mainly emails, but it also covers calls, it covers SMS texts, and it covers the use of cookies. So you've got PECR to thank for that wonderful cookie bar that appears at the bottom of every website, or should appear at the bottom of every website, I should say, because not everybody gets it right. And that governs the use of cookies. Again, that is under some changes at the moment under the Data Reform and Use Bill. The new bill, when it becomes an act, is likely to merge these two together, which in some ways will be a good thing because it simplifies things. But we're doing this today. I have to tell it as it is today because the new bill is not yet gone through Parliament. So the essential difference is that GDPR governs how data is processed. PECR governs how messages are sent. So essentially how that data is used. But it's important that we understand both of them if we're going to keep our marketing legal. So what are the common mistakes that people make? When you're looking at it under GDPR, which of course doesn't actually include the sending of emails, as we just said, but people look at, oh, I must be able to send an email to that person because I've got a legitimate interest. Because I think because they satisfy the legitimate interest test under GDPR, that must mean it's okay for them to send emails to that person. No, the two are not the same. Actually having the right to hold data on someone and store that data and process that data, that falls under legitimate interest. But using it to send emails doesn't necessarily. It all depends where they sit, and we'll come on to that in a minute. One of the other biggest mistakes people make is they just buy a list of emails. You know, they buy a list of 5,000, 10,000 emails, and then they just go ahead and mark it out to them with no checks whatsoever. Whatever you do, don't do that, because if you email out to people using a list that you've purchased and they haven't consented to having third-party companies or people contact them, you could end up in a whole heap of trouble. So be very, very careful with purchased email lists, because also be careful with the price, because a good email list costs money to put together. So if somebody offers you 5,000 names for 70 quid, they probably haven't researched them properly, and I'd say stay away from that list completely. The other thing that people forget to do if they're doing mailings out to somebody is the adage under actually under GDPR, but is that consent must be as easy to remove as it is to give. And so it's really important that you give a unsubscribe option on emails if you're mailing out to people who you're relying on consent to mail to them. Then you should give them the option to unsubscribe. It's always good practice to give people the option to unsubscribe anyway from your emails, unless, of course, I don't mean that on transactional emails. I just mean it on marketing emails. So if someone is buying from you and you're having an email conversation, yeah, you don't need to include an unsubscribe option in those emails. But if you're just marketing, push, 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 then you should include an unsubscribe option, and that should be clear. Don't bury it away in the tiniest font known to man, 6 inches down the bottom of the page, because that doesn't really count as having a clear unsubscribe option. The unsubscribe should really be in the same text and the same size as the rest of the body text in the email that you're sending. And the other thing is that if you are relying on consent to send marketing emails and you've got that consent, keep a record of that consent, because if someone then challenges it in the future and says, yeah, you're emailing me, I've never given you permission to email me. I mean, it's my role as an external DPO for a number of companies, and I know I see that Joe's also on the call, and Joe's done this role too. Yet countless people saying, I never consented to you sending me emails, and then in fact when you look back you find that they did. They've just forgotten that they did. Although I will give a anecdote here, and those of you who've known me a long time will have heard this anecdote before, but I always use it, is I had one particular client where they had somebody who said, please stop emailing me, I've never given you my consent, and even if I've given you my consent, I now want to withdraw my consent. Fair enough. They hunted all through their database, all through every database they could find that they used. They couldn't find this person's details anywhere. So they assumed, oh, somebody else must have already deleted him. The next month, same thing, much more of a complaint. I'm going to refer you to the ICO, da 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 da. They passed that complaint on to me. I had a look with them. I looked through all their data. I could not find this person's details anywhere. So I approached them as the DPO and said, ever sorry you're getting these emails from us. We don't understand how you're getting them because we can't find your email address on our subscription list anywhere. To which the response was, I've never subscribed to your newsletter. My brother subscribes to your email and he forwards it on to me. And so, yeah, have to have a very gentle conversation of go and talk to your brother then. But yeah, it does show how it can be people can misinterpret what they're allowed to do. So when do you need explicit consent? Basically, if you're marketing to consumers, you must have explicit opt-in consent. No ifs, no buts. Doesn't matter if they're already a customer. If you're marketing to them, then you need explicit opt-in consent. And as I said, their consent must be recorded and easily withdrawn. And I always recommend to people that you store the date and time that somebody gave consent and their IP address that they're given the consent from, because then you've got a fairly good record that they have given explicit consent. But what if you're B2B? There it's a bit different, because if you've got an existing relationship with that other company, then you can use soft opt-in. Soft opt-in is a bit contentious, but in B2B marketing you can do it because PECR doesn't apply. So you can be a little more lax in how you market to people. Now, there's a big question on if someone gives you their business card at an exhibition, by giving you that business card, are they giving you consent to contact them? Technically, always a good idea if you're doing an exhibition to have a sign up on your stand somewhere saying that by giving us your business card, you consent to us marketing to you. Otherwise, I always tell my clients to treat it as being given permission to contact that person once. So you contact them once as a result of the show. You say, hi, great to meet you at the show last week. Da, 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 da. Here's the information you asked for. If you'd like more information, then we can do that. However, if you'd like to unsubscribe from mailing and not hear from us anymore, then just click here and just have an unsubscribe link, and it just saves a whole lot of hassle. And at the end of the day, you know what people would say? Well, yeah, but then it removes the point for me being at the exhibition, because if I if I collect 500 business cards and then 200 of them choose to unsubscribe, then I've only collected 300 business cards. Well, yes, you have, but think about it the other way, because using the old analogy of a problem is an opportunity looked at from the wrong end. If someone does not unsubscribe from that, those people you're now marketing to, those 300 people, actively want to hear from you. And I'd rather spend all day marketing to people who actively want to hear from me than people who may not. Because if they're never going to buy from you anyway, what does it matter that you're not communicating with them? It just does not affect anything. So just, yeah, just don't worry about it. So what else? Consent must be freely given. It must be specific, informed, and unambiguous. So consent must be given, and people must know what it is that they're giving consent to. I'm going to use an example here, actually, with something that happened recently when I was at my dentist's, which I was having, in a chair like you do, having some treatment, had their goggles on, didn't have my glasses on because they take my glasses. And as we're finishing the session, before she's given me my glasses, the dentist gives me this form and says, "Oh, can you fill this in? Because we want to add you to our mailing list and tick." And I said, "No, I'm not doing it without my glasses on, because I want to see what I'm consenting to." And so it is important that people understand what it is they're consenting to. And as I say, consent must be recorded. It must be easy to withdraw. And coming back to the B2B marketing bit a minute, I want to cover a couple of things which do get a little bit grey area, I think is the best way to describe them. One is, what if you're marketing to somebody about business, to them and their business, but they're actually using their personal email address? They're using their Gmail email address or a Hotmail email address. I would say just be careful. I would definitely aim to get consent in that case, even though it's about business. Get consent, because it's a personal email address. The other one, which is a bone of contention at the moment, and I know which side I sit on this, and some others who do what I do sit the other side of the fence, and that's fine. It's an open for discussion question at the moment. But what about if you contact people via LinkedIn? Now, I take the view that if someone's on LinkedIn, they're there to do business. And therefore, if I want to direct message them, as I did direct message people who are here on this call, I think that's absolutely fine. I don't have a problem with that. I don't see that that's an issue under GDPR or under PECR. Jump to that. There are those, though, who hold the argument that people are on LinkedIn as individuals, and therefore you should get consent before you market to them. And that's a perfectly valid point of view. I can see the argument behind that point of view. I personally don't agree with it, but I can see why people would argue that. So I'm just saying on LinkedIn, just be a little bit careful and just watch which way the wind is blowing. So practical steps for compliance done. Always get clear consent for B2C marketing emails. That has to be number one. Number two is use a double opt-in system. What does that mean? It means get someone to tick a box, but then also get them to verify that they've received an email that you've sent to that address. Why is that a good idea? It's more consent because they've done 2 steps to actually consent. It's actually better for you as well, because you know that that email address that they put in actually exists and that they have access to it. Because otherwise, what's the point? You know, there's big arguments for saying, I reckon if you went through all the mailing lists of all the companies in the country, especially the big companies, you'd be astonished how many people live at 10 Downing Street who are on their mailing list, because people just put in silly details. And what's the point of that? You don't want to market those people. They're never going to buy anything. Um, as a keep detailed records of consent. Provide an easy opt-out method. Make it simple. Don't make it difficult. Don't make people leap through hoops to have to unsubscribe from you. I had one company recently who I wanted to unsubscribe from. Admittedly, they were an American company, but they could not have made it more difficult because I ticked the unsubscribe box on the form. That's fine. It took me to another screen saying one of our operatives will give you a call to see if find out what the issue is as to why you want to unsubscribe. No, I don't want that. I don't want a call. I just want to unsubscribe. Just let me go. Because if I was going to buy, maybe going to buy from you before, I ain't going to buy from you now because now you've really hacked me off. The exception to that, though, is I would say that if someone is leaving your newsletter, leaving your marketing emails, and they're on and they tick to opt out, you take them to a screen saying you're going to opt them out, no questions asked. But at that point, have a page on your website that makes them an offer, that makes them a too good to be true offer that gets them maybe to stay. Why do I say that? Because at that point, they're hacked off with you anyway. So if you hack them off a tiny little bit more, it really doesn't matter. They're going. But that offer might just be enough to persuade them to stay. And we've done that with a number of clients, and we know that it works. You get maybe 10, 20% will actually say, you know what? Yeah, I'll take that 30% off. I'll stay. So and again, it's a paid technique. But the other thing that people don't do, and again, if you're in a situation, please have a word with someone, either myself or someone like me, is to regularly audit your marketing list, is to clean the list. And again, it actually makes practical sense. Why mail to people who no longer work at a company? So you're just getting loads of no longer here replies, or this mailbox is full, or whatever. Doesn't make sense. Don't want those people. But it also means you've got a nice clean list. And there are companies who specialize in data cleansing. I certainly have one or two that I can recommend. And it's well worth doing. And again, it makes sense because again, you're marketing to people who want to hear from you, and so that's the whole point of good marketing. So the consequences of non-compliance, and I'm going to say take this next slide very much with a pinch of salt, because, or the first two bits of it with a pinch of salt, because if you breach GDPR, you can get a fine of up to 20 million euros or 4% of global turnover. That's what the rules say. If you're in Italy or you're in Spain, that's very much true. The regulators in Italy and Spain love fining people. The regulator in the UK, the ICO, not so much. You do get occasional fines from them. You get some fines from them as well that never make it into the public domain because they don't need to go to court. They can just fine you. So you don't necessarily hear of all the cases. And so there are cases where people get fined a few £1,000s that no one ever hears of because they never get on anybody's radar. But under PECR at the moment, you can only be fined up to £500,000. And the ICO, to be fair, does fine people under PECR. The new Data Reform and Use Bill, which is, as I say, it's going through Parliament, is looking to merge these two. And so the PECR fine is thought likely, certainly the draft legislation is that the PECR fine will become the same as GDPR fines, and that could really have a big impact on people. Because suddenly, if instead of a fine of up to £500,000, you could be fined up to 20 million euros or 4% of your global turnover. It's a bit more of an incentive to actually comply. But I always say to people, regardless of that, forget about the damn fines. Worry about the reputational damage and the loss of customer trust, because you don't want people, especially two people do, people bleating on social media saying, I've tried 6 times to subscribe from this mailing list and they still keep mailing me because that just gets you a bad name. And it's an old adage, but it's true, is that reputation takes a lifetime to build and a second to destroy. So don't risk destroying your reputation. Don't risk losing the trust of your customers. Just don't do it. Keep your marketing clean. So key takeaways then. GDPR governs data protection. PECR governs electronic marketing. As I said, it governs other marketing as well. It governs marketing by phone, for instance. Um, don't do what somebody did the other day. I had somebody call me. My home number is registered with the telephone preference service, which is a service that says, don't call me on unsolicited calls. Somebody called me. I answered the phone. I said, "Are you aware this number's on the telephone preference service?" To which, instead of an apology or whatever, I got, "Oh, so what number would you like me to call you on?" Yeah, not quite getting a hint on that one, were they? But anyway, TPS is this. If you want to register your number with them, please do, and then it just stops people marketing to you on your phone. Always obtain clear and documented consent. Make it easy to opt out, and respect your customer preferences. If someone said they want to opt out, let them opt out. Regularly audit what you're doing in terms of marketing, because remember that compliance builds trust, and it builds stronger customer relationships, and that's surely what we all want. So with that, I'll put my contact details on the screen, and then I will take any questions.
I have a question, Keith.
Yeah.
Part of my job is to help people get processes, etc., automated within the businesses. So I'm all about having a single source of truth. But I do use a CRM, and it offers me to be able to save contacts from the CRM on my phone, in my Outlook, and all this. For GDPR purposes, is there a grey line there, or should you just keep everything in the CRM?
It's a tricky one, to be honest. I would say as long as you document somewhere where you're keeping data, then have it wherever you want. Um, but yeah, do make sure that you document it. So don't have in your privacy policy, for instance, that we only store data within our CRM, and then in reality, you got it here, there, and everywhere.
Okay, that makes sense. Yeah. Thank you.
No problem. Anyone else got any questions? And Joe, yeah, thanks for your comment in the chat. Joe's put that she agrees that contacting people via direct messaging on LinkedIn is okay, but not add to marketing lists, and I'd agree with that. Joe, anything you want to add?
I was just going to say this is one of those areas where it is so easy to slip up, and you do see so many newsletter sign-ups or freebie downloads on websites where it's mandated that you agree to marketing in order to get the freebie. That's not proper consent, and it is important to get it right, because it stands you in good stead for your reputation and for your business, really.
Yeah, absolutely. As I said earlier, so many people just don't think about reputation, really, and they should. And the other problem I think that you've got with PECR as it stands at the moment is because the fines are capped at 500,000. I certainly know one big household name, I won't name them, but one big household name that I spoke to about GDPR and PECR, and they had pre-ticked boxes on their website.
Yeah.
And they said, "Well, yeah, we know about that, but if we get fined 500,000, hey, we can swallow that, so we'll just swallow it."
Yeah. There is a very popular pizza organization that until very recently had the marketing checklist pre-ticked, and you had to opt out. And their justification for that was that if you were buying a pizza, you were their customer, so they had that legitimate interest. But that what they failed to account for was the fact that with B2C, it should have been opt-in, irrespective of whether you were buying something for them or not.
Absolutely, yeah. People just it's that distinction that people sometimes don't get, and unfortunately, I think it's one of those things again where things like ChatGPT don't help, because if you ask ChatGPT, it'll probably say, "No, customer, you don't need you don't need to that," because it just gets it wrong. It's ChatGPT. I will just do a quick plug. ChatGPT is great if you train your own GPT. Which if you have the paid version, then you can do that. You can train your GPT so it knows what the right answers are. I mean, I have a GPT which I use, but it's been trained on my 6 or 7 years of training material. And so, you know, hopefully it gets it more right. But I still manually check each answer that it produces before I send it out. I don't let people just get the default answer from the AI engine, because, yeah, AI can save us all loads of time. It saves me masses of time, but it still needs, to my mind, still needs that manual check. Karen, good to see you.
Right. I've got a question for you, Keith.
Mm.
I've got a client who's currently cleansing their data. They're moving their data from MailChimp to another database. But on that data, she has created a mailing list from a membership that she's part of. So let's say, for instance, like a membership for a chamber. And all those email addresses are fully available because you are a member and you can engage with those people. Can she mail them directly without having that verbal consent, or does she have needed to have had that exchange of business card?
Good question. I would say two things on that. One is obviously she should check what the actual rules of the chamber are, because I mean I belong to a number of networking groups, and some of them actually say you must not contact these. You can have just one-to-one contact, like pick up the phone to people, but you shouldn't put them on a blast mail and just mail them. So that's number one. But B is I think again it's down to interpretation. My personal feel would be that by being a part of that group, people are saying, "I want to contact people. I want to do business."
Yeah, I think that's her mentality, but obviously,
and so
I
I think the way I would do it, and I'd be interested in, I mean, Joe's a very similar person role to myself, so I've known Joe a long time, so I'd appreciate Joe's input on this as well. But my personal view would be that mail them once, but give them the option to say, if you don't want to hear from me anymore, then click here or whatever.
Yeah.
And I think that just covers all the bases. Joe, would you agree with that? Or?
Yeah, I mean, I think the important thing is when we're talking here about consent, it is that people have the option to give you consent, and they have the option to opt out as well, and that you can control that. And where you are meeting new people or something like that, one of the things I say to people is, if you're meeting somebody new and you want them on your mailing list, there's nothing wrong with you sending them a very tailored email from Outlook saying, "Hi, we just met at this networking event. We had this great chat about, would you like to join my email list?" And give them a form to sign up. And you're building your relationship. Remember that marketing is about relationships, because people buy from people. They don't buy from your marketing list unless they know, like, and trust you. And part of that is operating in a compliant way. And you start that relationship by inviting them in, through sort of a general Outlook email, you know, just remind them, where did we meet? Why am I sending you this email? Would you like to receive my newsletter? I send out lots of information on, you know, tips and hints on how to do whatever it is that you provide. And use your mailing list to enhance your your reputation through operating it correctly, but through marketing your business genuinely, would be my advice every single time. So I hope that kind of helps with, you know, because don't be afraid of data, and don't be afraid of, you know, contacting people. GDPR and PECR is not about I can't market to people. It is about transparency and respect for people's data. So if you operate with that in the forefront of your mind, you know, and again, following on from that, it's consent or it's legitimate interest with the relevant assessments, etc., then, you know, it's less, there's less chance of you kind of making this huge massive mistake, like buying 10,000 email addresses where you've got no idea who they are, where they've come from, whether the consent is there, you know. So be open, be transparent. And I think, I don't know whether you'd sort of add anything different on that as well, Keith.
No, I think you summed it up really well, Joe. Yeah, it is. And I mean, one of the things that I always say to people when you're considering marketing to somebody and just in your relationship with that person is put yourself in their shoes, and you know, would you expect to receive that from me? And you know, if I'll use Joe as an example, because I know what Joe does, and she knows what I do. If I sent Joe my newsletter about GDPR, she'd probably be quite happy with that. It probably wouldn't be an issue. If I suddenly sent her a newsletter about, you know, the latest greatest things in greenhouses, she probably would question that and say, "Why have you sent me that?" Because it wouldn't be what you built the relationship around. And I think I think that's the key thing. You know, business has always been about relationships. And as Joe said, at the end of the day, people buy people. And whether I mean, a firm belief of mine is whether you're selling widgets or you're selling Rolls Royces, people still buy people. And if someone doesn't like you, they're not going to buy from you. And one of the ways to get them not to like you is to bombard their inbox every 5 minutes with emails that they've not asked to receive.
I was interested you said about you should make it very clear it should be in the same font for people to unsubscribe, because I've got someone that regularly emails me and I'm desperate to get off their mailing list, but can I find how to unsubscribe? No, I can't. It's driving me mad. As soon as I think, I just delete.
My advice in that case would be to send them an email and say, I would like to be removed from your mailing list, and I would like that done by, I don't know, Friday the 14th of March, for example. If they still do not remove you, this is my approach, so it's very personal what I'm saying to you, is I mark their email as spam. It then doesn't come into my inbox bothering me, but also if you mark somebody's email as spam, it doesn't matter which tool that they're using, that email then damages their sending reputation. And that's kind of getting into the technicalities from the tool set perspective. But if they're not going to operate compliantly, then what you need to do is sorry, my dog walker's just been collected the dog and set the alarm. So I don't know if you can hear the buzzing in the background, but I'm going to have to switch it off in a second when it stops buzzing. But that's my approach. One of the things that I have found is B2B emails they send them sort of like BCC out of Outlook, so there's no unsubscribe at the bottom, and that may be what is happening, Karen, because if they are using MailerLite, Active Campaign or anything like that, the tool automatically puts the unsubscribe because it's mandated, and the tools take away the option because it's always there. So if there is no obvious unsubscribe, what that means is that they might be doing it as a BCC out of Outlook or Google or whatever. And if that's the case, if you email them and say, please remove me from the list, and you are still not removed from the list, then you've got no alternative but to mark that email as junk, spam, whatever your tool asks you to do, because then it stops it bothering you. Excuse me, I must just sort my alarm out, or else it's going to go ballistic in a minute,
No
because
problem,
it'll
Jess.
know that I'm here.
Okay, very, very helpful. Thank you.
Yeah, no problem at all. No, that's been really good. It's been really useful discussion, I think. So just a reminder that we are here every other Wednesday, so every 2 weeks throughout the year. Always at the same time, 9 o'clock on a Wednesday morning. Recordings of the each one do go out on a Thursday. But if you know people who have signed up to attend and they're not here, please do them a pod, because as you can see, it's far better if you are here, because you get a chance to engage in the conversation rather than just have the recording. In the weeks in between, the weeks when we don't send out the we don't have the lives, we have a GDPR Chronicle newsletter, and you can find details of that on my LinkedIn profile, and please do subscribe to that too. We've got, I think, just shy of 2,000 subscribers now, so it would be great to have extra subscribers on there. Other than that, thank you very much for being here. I'll let you all get on with your Wednesdays, and I hope you enjoyed the session.
Okay, thanks
Thanks,
very much.
Keith. Take
Thanks.
care.
Bye.
Bye.
You